This is the beginning of our third and final panel for the day. My name is Paul Avelar. I am the managing attorney of the Institute for Justice's Arizona office. It's my honor to be with you here today to essentially drink from the fire hose of Arizona constitutional originalism. I'm sure you're all able to take in absolutely everything that we're throwing at you, but I think the real goal of today's event is to get some people thinking about new issues and new ways of thinking about them as we continue to litigate and judge and think about the Arizona Constitution. I'm going to introduce each of the speakers today seriatim as we go along. This panel is rather bloodlessly called Other Significant Provisions of the Arizona Constitution. This, of course, raises some obvious questions. Are there insignificant provisions of the Arizona Constitution, and what are they? To be frank, I preferred the original title of this panel, which was maybe not better, but Significant Miscellany. Yes, miscellany. I'm not sure that there's a uniform idea or topic that ropes us all in together today, but definitely significant. Why? Well, in some ways, what we're going to talk about in this third panel is uniquely Arizona. And at the very least, I think the topics covered in this panel forces us to get out of the usual mindset for doing state constitutionalism, which is, rather than as its own thing, a sort of weak compare and contrast to federal constitutional provisions. You can't do that with the provisions that we're going to be talking about today. You have to attack them at on their own terms. Again, a very short intro to each panelist as we go through. Their bios are in their packet, and like I said, I'm going to introduce them as we go along. So the first up is Tim Keller, General Counsel at Gen Justice, and here I am required to apologize to Tim because education is not a provision of our Constitution. There is an entire article, Article 11, titled Education, and there are relevant provisions in other articles. And in fact, education was actually a provision in the original Statehood Enabling Act. That has been carried over into our Constitution in Article 20, Section 7. Provisions shall be made by law for the establishment and maintenance of a system of public schools, which shall be open to all the children of the state, and be free from sectarian control, and said schools shall always be conducted in English. And that is what the federal government said that had to be in our first Constitution. And in fact, they said it had to be there, and the people of Arizona were not allowed to amend that provision without Congress's approval, which is totally wrong, and one day we'll get to litigate that. But there's more than that. There's also provisions in Article 7 and Article 9, one of which I know Tim is talking about today, the prohibition of public aid to private or sectarian schools. And with that far too much introduction, Tim Keller.
All right, well, thank you, Paul. I want to begin by thanking my summer law clerk, Maddie Shoup, who is here today. She put together a thorough memo covering all of the provisions of the Arizona Constitution that touched on education. She pulled all the cases, she synthesized them for me, and if we really wanted the genuine expert on the Arizona Constitution's education clauses, we'd have Maddie up here instead of me, because I made the decision to limit my remarks to the context of K-12 education. And also to try and do my best to limit my remarks to the actual education article, Article 11 of the Arizona Constitution, although I will touch on some of the other provisions as Paul suggested. Although if you looked at my prepared notes, you wouldn't see any of that, but as I've been talking to folks throughout the day, it's become clear that there is an expectation that I will touch on those provisions because I was invited here today, I'm sure, because of my prior work at the Institute for Justice, litigating and defending school choice cases all across the country, defending those programs from legal attack under state and federal constitutional provisions all over the country. So that was my prior work, and that's what I think garnered the invitation here today. So I will start by addressing private school choice programs under the context of the Arizona Education Clause. there are basically three types of private school choice programs that Arizona has enacted over the years. All three of them have been subject to legal challenge at one time or another. All of those cases included claims that the programs violated portions of the Arizona Constitution related to education. The predominant articles were Article 2, Section 12, what the Arizona courts called the Religion Clause, which I guess would be the analog in our Constitution to the Federal Establishment Clause, as well as Article 9, Section 10, which says that there shall be no aid, and which the Arizona courts have become to call the aid clause, no aid to sectarian institutions, including private or sectarian schools. Those provisions, like I said, predominated the litigation. The first cases involved an Arizona tax credit program whereby individuals could donate to private nonprofit organizations, get a dollar-for-dollar tax credit for that contribution to the scholarship organizations. The scholarship organizations would then issue scholarships to students. The students would apply to those private nonprofits for those awards. And there was a claim that the Article 2, Section 12, Article 9, Section 10 were violated. In the original case, Cotterman versus Killian in 1997, there were no claims regarding the education article or the education clause. Instead, there was an argument made in addition to those two claims under the Arizona gift clause, all of which were determined not to prevail. The Arizona Supreme Court rejected all of those arguments, said that there was no public money involved with a tax credit program. They were all private contributions to private scholarship organizations, and therefore no violation of the Arizona Constitution. The next iteration came in the form of a different tax credit program. This was a corporate tax credit program aimed at low-income students. It essentially operated in the same way as the individual tax credit program did, except it was corporations making those contributions to those nonprofit scholarship organizations. And in that case, in addition to the Article 2, Section 12, and Article 9, Section 10 claims, the plaintiffs in that case said that the program violated the Arizona Enabling Act. As Paul said, Arizona was required to include in its state constitution provisions making provision for a general and uniform public school system. The specific language was that in the Enabling Act was that they were required to establish and maintain a system of public schools open to all children. And the court, the Arizona Court of Appeals, in a decision called Green versus Garriott, authored by John Gemmell, rejected that argument and said that the Arizona legislature had met the provisions for creating a general and uniform public school system that was open to all students, and the fact that they also had created a program by which private individuals could make private contributions and receive a tax credit for those to fund scholarships for students attending private schools, did not violate the Enabling Act. So you can read Green v. Garriott and see the Justice Gemmell's very clear, very cogent arguments there. The next iteration of school choice litigation in Arizona involved two private school scholarship programs that were enacted in the state, one for children with special needs and one for children in foster care. There were two very small programs. Each program received a $2.5 million appropriation from the state general fund to fund those scholarships. They were challenged again under Article 2, Section 12, Article 9, Section 10, and this time the plaintiffs also invoked Article 11, Section 1 of our Constitution, which mirrors the language in the Enabling Act, but which is slightly different. So the Enabling Act said the state shall establish and maintain a system of public schools open to all children. When the legislature, when the founders and framers of our Arizona Constitution translated that requirement into our Article 11, Section 1, they said public school system, or the legislature shall enact such laws as shall provide for the establishment and maintenance of a general and uniform public school system. The Arizona Court of Appeals did not reach that issue in that case. It struck down the voucher program under the aid clause. Article 9, Section 10 said that because the Parents who received scholarships had no choice but to use them at a private or sectarian school. That program clearly aided those schools and therefore had to be struck down, didn't reach Article 11 or Article 11, Section 1 at all. Although it did note that the plaintiffs had brought the claims. When that case reached the Arizona Supreme Court in Kane v. Horn, the Arizona Supreme Court affirmed the decision under Article 9, Section 10, and again did not reach the other claims in the case. That brings us to the third iteration of private school choice, the Arizona Education Savings Accounts programs. This program differs from a voucher program in that parents have what their student would have received if they had attended a public school into a separate savings account, and they're able to use those funds for a variety of educational uses without having to enroll them in a private school. And even if they do, they don't have to use the ESA funds to pay for the private school tuition. They could pay for that out of pocket and use the ESA funds for all of the other various authorized uses from the ESA, including paying for public school courses on an individual basis at Arizona public schools. So again, we saw the same set of claims brought against the ESA program. In that case, the Arizona Supreme Court differentiated the voucher program and said, unlike the voucher program, the families receiving the benefit aren't forced to use it. They're not required to use it at a public school, so there's no violation of the aid clause. And in that case, the education article claim that was brought was not that it violated the requirement to establish and maintain a public school system, but rather that because one of the requirements of the ESA program was that students had to sign an agreement that they would not enroll their student full-time in a public school, that there was an unconstitutional condition requiring citizens to waive their right to a public school education in order to participate in the ESA program. The court rejected that because it was a voluntary agreement and they could withdraw their participation in the ESA program at any time and re-enroll their student in the public school without any penalty. So that argument was rejected. So there you go. That's the quick view of the private school choice landscape. I don't know how much time I've got left, Paul, but a little bit, right?
A little bit, yeah.
All right. So let me just note a couple of observations about the education article of the Arizona Constitution. First, the provisions of Article 11 really track quite nicely along with the actual enabling act that we were required to enact as a result of our condition of statehood. Is a very workmanlike product, in my opinion. There was a number of additional language proposed as part of the convention when our framers were putting together our education article. For example, they considered adding language to this effect, that a general diffusion of knowledge and intelligence being essential to the preservation of the rights and liberties of the people, the legislature shall establish and maintain a general and uniform public school system. They also considered saying that the stability of a Republican form of government, depending mainly on the intelligence of the people, but ultimately, all of these prefatory provisions were rejected because, quote, it was too much like a good old-fashioned democratic speech. And instead, they just focused on what the legislature was required to do as a result of our condition of statehood. And there's a lot of direction and a duty imposed on the legislature to enact certain types of laws. And there's also requirements that the legislature delegate to a state board of education the responsibility for defining the contours of our public education system. So what I see is a duty imposed upon the legislature to enact laws, essentially delegating to our state board of education how to go about setting up our public school education. So there's duties and there's delegation, but I also see a lot of discretion in the Arizona Constitution. The Arizona Constitution's Article 11, Section 1, and subsequent sections say very little about the content of what is supposed to occur in our public schools. In fact, to the extent they say anything about content, they say that it shall be free from sectarian instruction And there's a really interesting side note we could take into the original public meaning of the term sectarian instruction as it relates to private school choice programs and the infamous Blaine amendments. But really it's unnecessary because the Arizona or the US Supreme Court has said under the Establishment Clause there shall be no religious instruction in our public schools, right? So that would be an interesting discussion, but that's not worth having because we know that Arizona public schools cannot provide any sort of religious instruction. And then the other thing it says is regarding liberty of conscience, that nothing in the laws that the legislature passed shall justify practices or conduct inconsistent with good order, peace, morality, safety, or the rights of others. And that's a provision that has received virtually no judicial attention over the years. So
It is my obligation to
cut you off. I understand.
But I get to ask you a follow-up.
Sure.
And you've used a couple of terms today that seem unusual for constitutions, as we tend to think of them. You said there is a duty imposed on the legislature to do something. The original Enabling Act says provision shall be made for a public education. We think of rights, when we're talking about the federal Constitution, as negative rights. Does the Arizona Constitution create a positive right to a public education? And if so, how do we as litigators and as judges deal with that when it comes to little things like, remedies?
Yeah, so as you say, Article 11, Section 1A says the legislature shall enact. And so I think that does result in a positive right of all children in Arizona to be able to enroll in a public school that the state establishes and maintains, and as the Enabling Act says, keeps exclusive control over, quote unquote, forever. But I see very little beyond that in the Arizona Constitution. So I don't think there is a viable claim for potentially educational malpractice in the state of Arizona. The type of educational equity suits that we've seen prevail in other states, I don't think would be successful here if you were to say the content of the education being provided in our public schools is genuinely inadequate. I just don't see the constitutional requirement for a specific level of contact. Now, our Arizona Supreme Court has said that the minimum requirements is that they create an adequate public school system, but I really think that if that were to be pressed, similar to what we've seen in the higher ed context, the courts would say that that's a non-justiciable political question, is my instinct, and that you wouldn't see a lot beyond that imposed in the Arizona Constitution.
And with that major question hanging over us, let's move on. Next up, we have Judge David Weinzweig of the Court of Appeals, Division 1, on monopolies and trusts. And so here, unlike education, we clearly have one provision to discuss, Article 14, corporations other than municipal, Section 15, monopolies and trusts, but maybe there's a couple of other provisions of the Arizona Constitution that relate to this as well. It's not entirely certain. In any event, the framers clearly thought of monopolies and trusts as being important enough to include in the Constitution. Why? And where does that lead us today? Judge Weinzweig?
Hello, everybody. And first, I would ask that you not run for the exits. Antitrust is not the most popular of topics. I remember 20 years ago, I was the chair of the antitrust section for the Arizona State Bar, and I wanted a big event. So I said, who can I get that will draw a crowd? I said, Posner. And so I reach out to Posner. Email address isn't hard to figure out, thinking he wouldn't write back, but who would guess this lion of antitrust law writes me back, and I said, hey, will you come out and speak to the antitrust section? And he told me, I will on one condition. And I said, what is the condition? And he said that I don't have to talk about antitrust. So he comes, it's a story for another day. He doesn't tell me the topic. It's the old Great Hall at ASU, full crowd, must be a half dozen Ninth Circuit judges. And he said, I'm here today to talk about how the Ninth Circuit is both bloated and underperforming. At that point, I thought my career was over. And I don't know if you know where I worked. I got in a lot of trouble at my law firm. Okay, so the founders, our founders, were, as I'm sure you've heard today, suspicious of government overreach, but they were also concerned about concentrated market power and large private interests, kind of like it's a fear of the robber barons of the industrial era. And so I think to fully appreciate this provision, Section 15, Article 14, it's important to look at when this was adopted. So the climate of the times, Constitution ratified in 1910 and then approved in 1912. 2 years before the Clayton Act was passed. Now, I guess for those of you who aren't familiar with antitrust, federal law, you have the Sherman Act, which was passed in 1890, and it's written like a constitution, very vague, abstract words without any definition. So restraint of trade instead of price fixing. And so from 1890 to 1912, 1914, large corporations are sort of like a colander. They're able to get their anti-competitive conduct through the Sherman Act, and so the Congress in 1914 passes the Clayton Act, which is far more specific and expanded the federal antitrust law footprint. And so now look at Arizona. Arizona's constitution is approved 2 years before the Clayton Act, 22 years after the Sherman Act, and nationally, there's a lot of concern about market power issues, and especially here in Arizona, where many, well, I don't know if I would say the founders, but many people suspected large interests were playing sort of a devious role in, fill in the blank, whether it's statehood and sort of controlling things. So very, very distrustful. And so the Arizona framers included an express restriction on monopolies and trusts. And unlike the federal Constitution, the Article 14, what it says is monopolies and trusts shall never be allowed in this state, and that no person or entity shall directly or indirectly combine or make any contract in any manner, and then it starts hitting more concrete sort of well-known offenses like fixing prices, agreement not to compete, and so then the last sentence says, just as we were discussing, it's a shall. It says the legislature shall enact laws for the enforcement of this section. And so that's what the legislature did. In 1912, Chapter 73, Arizona adopted an ambitious effort which described far more expansive protections than federal law. One of my externs pulled it. It's in your materials, but it specifically addressed. I mean, looking to the Constitution, it outlawed price fixing both high and low, so super competitive and predatory pricing. Non-price restraints, quality, we compete on both price and non-price elements, non-competes, monopolies, and unlike what we have today, it said nothing about looking to federal law to interpret our antitrust laws. All right, so fast forward 1912 to 1974, and Arizona adopts the venerable Uniform State Antitrust Act, which was adopted by all of 4 states, only one of which, Arizona, adopted it in full. So uniform is an overstatement. But what do we do at that point? We basically, it's the Sherman Act doppelganger. It pulls back from the specificity that you see in the 1912 statute and talks about contracts and restraint of trade, and we don't like monopolies. Very, identical language, and it includes a clause that says it is the intent of the legislature in construing this article that the courts use federal law, federal court interpretations as a guide. All right, so how has this all shaken out? And by the way, I'm sure I could ask you, where do you think we pulled our Article 14, Section 15 from? Washington. Hey, whoa, crazy. Yeah, so, and I think they passed it in 1889. So how has this worked out in Arizona? Well, Arizona really did not in any way differentiate itself between 1912 to 1974 to make it easier or harder to press the competition laws, and really not much different happened under Arizona law, which kind of just would always say, look at the federal government, look at the Sherman Act, look at the Clayton Act, until Bunker's Glass in 2003, which was my case, and that is the notorious indirect purchaser rule. So what does that mean? So a standard market, it's a continuum. It has multiple participants. You have manufacturers who make a product. You have wholesalers who purchase a product in bulk. You have retailers who purchase the product from wholesalers for their stores. And then you have the consumers who purchase it. So let's say there was a price fix on a spark plug in Michigan or Arizona, and it goes through a line of commerce, and that spark plug finds its way into your Honda. Okay, well, you don't have a direct purchasing, similar to privity relationship with the price fixer. And what does federal antitrust law say? You have no claim. It's too complicated. How are we going to figure that out? And that would kind of be hard to figure out. But it's an absolute bar. So let's say it's a complete pass-through, where it's just someone buying a good and passing it on. Well, federal antitrust law, after Illinois BRIC, precluded that plaintiff from bringing a case, any case, monopoly, restraint of trade, price discrimination, Robinson-Patman. And so it comes to Arizona, and there's several cases that raise the issue. And what I argued at the time, or I was working for the government, what we argued was that Arizona is different. Arizona, unlike the federal government, has this built in its constitution and uses the words, I think, if you look at it, direct and indirect, almost envisioning what would happen. And so Justice Birch bought it, right? We won. We won. And what was most important, at least for purposes today, she said, we believe that the guidance of our framers, the framers of the Arizona Constitution, provides sufficient reason to depart from the federal path. The framers, keenly aware of the harmful effects of monopoly power, enjoined the legislature. And in order for the antitrust laws to mean anything, we need to give indirect purchasers an action. Now, there was a dissent. Justice McGregor dissented, and she had none of that. She said the legislature was clear that we are supposed to conform, although it doesn't really say conform, I think it's more guidance, to federal antitrust precedent, and so she would have recognized Illinois brick. So I was only asked to talk about Section 15. I didn't go on.
That's quite all right.
Sorry. Right.
But I do have a question for
Yes.
you, which is the case you're just talking about suggests that the language of this provision is actually self-enforcing, because it says no monopolies, restraint of trade, et cetera, shall be allowed. And then it goes on to say the legislature shall adopt laws to this effect. The legislature adopted laws to this effect, and yet in that case, the court seemed to say, no, we're going to put primacy on the original language of the Constitution. Notwithstanding, the legislature has said, follow federal law's guidance. Is that, am I way off base there?
No, I think you're right on, and I think that it's an even better question, considering that in 1912, which was, I think, closer in time to the Constitution, we had a statute that was much more detailed and said, don't look to federal law. It was only in the 70s. Now, I'm not saying it's a good or a bad thing. And as a lawyer, it would depend on who I was representing. And as a judge, I'm just going to enforce the law. But I think that's a very good point.
Thank you for that. Moving on again to an entirely new topic. Judge Cindy Bailey of the Court of Appeals, First Division, is here to talk about torts. And again, an apology is necessary to Judge Bailey because there is not a tort law provision of the Constitution. There are multiple provisions of the Constitution touching on tort law. I don't want to bore them with you here. They're mostly in Article 18. Judge Bailey's going to run through them, I think, and if not, they're certainly in your materials. Judge Bailey, what does the Arizona Constitution have to tell us about tort law?
Well, I'll start by saying I'm the only woman who was asked to present. I got stuck in the other category and I got torts. So that's how I rate. No, I'm honored to be here, and in common with Tim, I give a lot of thanks to Aaron, my law clerk, and for those of you who are trial court judges or public lawyers, a law clerk is this really interesting concept where you have someone who gets paid very little but who did better than you in law school, and they help you with these really hard projects. I also have an extern who helped, Aiden Wright, who's here today too, and Aiden learned today that you can be assigned a research task and then end up with having none of your work reflected in the final product. So thank you, Aiden. There's an impulse, I think, among us that tort law doctrine mixing with originalism is like oil and vinegar. What does one have to do with the other? On the one hand, courts interpreting a constitution are supposed to give effect to words on the page, rightly defined, but common law by its very nature, it's judge-made law that adapts to the interests of justice and efficiency and is necessarily contingent. But in our Constitution, our framers have forced the two things together. And what they sought to do was protect the common law rights to which they and others in the common law world were accustomed to in matters of things like industrial accidents in particular, against the backdrop of Lochner-era contract rights, and as we've heard many times over the course of these talks, wildcat corporations, which were a big concern. So torts, interestingly, are the primary substantive and doctrinal interface between the Constitution and the common law. But when the framers were given the option of going big or going home, they did not go big. And in fact, in 1957, the Arizona Supreme Court says, we're not going to assume that the framers intended to change or make any innovations to the common law, absent language to the contrary. And the evidence of this is striking when you look at the minutes, as other people have done, of the Constitutional Convention, and they don't reveal a single proposition where the framers were trying to expand any causes of action, even when they were limiting some defenses. So they instead sought to codify the protections, rights to sue for wrongful death or injury, rights to damages, rights to jury review of certain questions. And so they had the opportunity to enlarge or expand, and they chose not to do that. So we kind of could say we have a progressive conservative constitution which sought to bulwark our common law rights against modern changes that you've heard about, corporations, industrial accidents that threaten those common law protections. So we can look at some of the concerns of the day, as we've heard previously. Roger Henderson's seminal article on how these provisions came into our Constitution is included in your CLE materials, and he includes an interesting story. In 1891, a man was killed crossing a Southern Pacific Railway in Casa Grande, and his survivors brought a wrongful death claim, and they were awarded $50,000, but threatened with this verdict. The papers of the time tell us that railroad companies induced legislators to cap wrongful death damages at $5,000. And typical of the era's journalism, this was mostly a false story. The jury did award a substantial sum, but it was the trial court that reduced the amount from $18,000 down to $18,000, which is still $500,000 in today. And even this was vacated by the U.S. Supreme Court. Nor was the damages cap introduced by a Greece legislator or some powerful rail baron. It was, in fact, introduced as a copycat to a Wyoming statute by a legislature with no railroad interests and unanimously passed by both houses. And so here, neither the facts nor the law really mattered. The yellow journalism was aimed at delegates elected to the Constitutional Convention in 1910 and reflects the concerns of the framing generation, which were the combination of corporations and powerful interests generally taking away the traditional rights of redress out of the hands of the little guy. And to be sure, that was only one of the concerns of the time, as Henderson demonstrates in his article. Most of the political rancor was reserved for direct democracy provisions that may have threatened to torpedo statehood. And another part of it is that they were very concerned about the fairness of the courts, and at one point in the Constitutional Convention, there's talk about whether there should be, they should forbid any injunction from being allowed by a court in order to protect workers who could strike. So as originalists, we can look at these concerns another way. Torts provisions were predominantly concerned with protecting the economic liberty of the working man. And I'm just going to go over a couple of the main provisions that we do. So in our Declaration of Rights, Article 2, Section 31, before it was amended with the Crime Victims Bill of Rights, it said no law shall be enacted in this state limiting the amount of damages to be recovered for causing the death or injury of any other person. And over in labor, way down in Article 18, Article 6 says that I'm losing my spot. I'll get there in a second. Article 18, Section 6. So it's noteworthy that, if not from an interpretive standpoint, then at least a philosophical one, that the framers wanted to include the right to damages among such rights as due process, habeas corpus, the right of free speech and press, over in Article 2. And although the title of that doesn't do much for signaling importance as to statutory interpretation, obviously they thought this was a fundamental right that they wanted to include there. And while both this provision and Article 18, Section 6 are frequently tied together, Article 2, Section 31 only prohibits damage limitations and says nothing about the text about causes of action. Our Supreme Court, however, has coterminously interpreted these provisions over time and conflated them. And in fact, in Jimenez versus Sears v. Roebuck, they said that the two must be read together and intend the same result. But if we were elevating ourselves to an Arizona Supreme Court justice for a moment, which I would never want to do, no, I'm just kidding. Article 18, leaving aside the Crime Victim Bill of Rights amendments, contains no mention of death or personal injury. Article 2 does, but Article 2 contains no mention of rights of action, which Article 18 does. But despite these disparate provisions, because we read them together, our courts say things like Article 2, Section 31 is not implicated under a claim of property damages and presume that we are done, even though the broader word injury rather than personal injury appears in Article 18. But does it make sense that we have applied two similar but not identical provisions nearly coterminously? To the extent we've distinguished between them, the case of Cronin v. Sheldon stands out, in which the court stretched Article 18 to constitutionalize causes of action not already covered in Article 2. And there is a practical effect of this. The voters, as I said, amended both provisions when they passed later Crime Victim Bill of Rights amendments and used identical language, even though those two provisions have different language. So it does have an effect when we say things like conflating them down to have provisions that have different language mean the same thing. In 1956, in the Downs case, we said that neither provision prohibited limits on punitive damages, and the reasoning was not a model of textualism. There were no fights over what dictionary definition they should use for punitive damages. They simply said that the most common definition of damages was compensatory and not punitive. The legislature took that up and superseded it by statute, but it's one of those things that if the legislature ever changed their mind, we might want to go back and read them separately. Let's pass over a couple other provisions before I close. As I said, the convention distrusted the courts. And Article 18, Section 5 straightforwardly takes the question of contributory negligence and assumption of risk out from a judge and gives it to a jury. This was in lieu of broader provisions which sought to eliminate the defenses altogether and instead copied an Oklahoma Constitution provision and a recently enacted federal statute concerning liability for common carriers. And then we have, lastly, an interesting nexus between contracts and torts in Article 18, Section 3, which prohibited contracts that, in exchange for employment, absolved employers of all liability. Our framers were motivated by concerns that entities would foist the economic and human costs of industrial accidents onto the state and its people. And considering what we've already said about the framers' thinking, that makes sense in keeping with the common law expectations. So the bottom line is that our framers sought few sweeping innovations in these provisions. We've gotten better through the years, but we have to question whether we should be reading language that doesn't have identical wording in it the same. And when people outside of the law are looking at those, they need to remind us that we have a unique past that was interpreted and printed in the text, and that they should ask us to use the text that way from here on out.
Thank you. A follow-up question, because you mentioned that there's been an amendment or two in this area over the years. How did that affect your approach to the originalism questions here? Does it reset the timeline, or how did you approach that as a judge, or what did you tell your clerks to do in lieu of that?
Well, I mean, there's a lot. We didn't touch on workers' compensation, which you can see a lot of back and forth, both early on in the original 1910 language, where you got to choose whether you use workman's comp or a civil remedy after you were injured, and that issue kind of went back and forth with a couple constitutional amendments over time. But I think, we've heard a lot about what originalists should do. I'm not going to try to top what the justices in the room have already said, but I think that the words mean what the words mean in context of the time and what was happening. I'm not sure you do anything differently than you do from looking back at something from 1910. And even though that's the boring answer, boring sometimes is the correct.
Well, thank you. And to shift gears in an entirely new direction, once again, last but not least, we have Justice Bill Montgomery with us. As you might imagine from the title Justice, he's on the Arizona Supreme Court, and he is here today to talk about the victims' rights provision, which I guess is technically a provision, but one with a whole lot of subparts. It's Article 2, Section 2.1. One, of course, and this is the reason why we're closing with this, that is much more recent in origin than most of what we have talked about today. In fact, maybe all of what we've talked about today. And how does that change the way that we do originalism when it comes to the Victim Bill of Rights? Justice Montgomery.
Well, thank you, Paul, and thank you for putting me between everybody here and alcohol. So I will move quickly. Easily passed by voters in 1990, the Victims' Bill of Rights, or also known as the VBR, amended our Constitution via the initiative process by adding Section 2.1 to Article 2 of our Constitution, and protects a victim's right to justice and due process by setting forth a number of specific rights. I won't go through all of them, but to touch on a few, at Article 2.1A1, to be treated with fairness, respect, and dignity, and to be free from intimidation, harassment, or abuse throughout the criminal justice process. At paragraph 3, to be present at all criminal proceedings where the defendant has the right to be present. Paragraph 4, to be heard at any proceeding involving a post-arrest release decision, a negotiated plea, and sentencing. Paragraph 10, to a speedy trial or disposition and prompt and final conclusion of the case after the conviction and sentence. At paragraph D, there's a realignment of authority for passing procedural laws, in which it provides the legislature or the people by initiative or referendum have the authority to enact substantive and procedural laws to define, implement, preserve, and protect the rights guaranteed to victims by this section, including the authority to extend any of these rights to juvenile proceedings. And then pursuant to Section 2.1D, the legislature in the very next regular session in 1991 enacted implementing legislation which can be found in Chapter 40 of Title 13. The first published opinion of the Arizona Supreme Court to address the provisions of the VBR is Knapp v. Martone, which considered the definition of a victim and provided initial interpretive guidance readily recognized by original public meaning proponents. Page 239 of the opinion, the court stated quite simply, it is important to emphasize that Arizona courts must follow and apply the plain language of this new amendment to our Constitution. The court thereafter noted that the trial court had held that Mrs. Knapp, not the named defendant in the case caption, was not a victim at all on the theory that the drafters of the constitutional amendment did not intend to include as a victim a person who, quote, was, is, or could be a suspect, close quote, in a case. Now, the Knapp court then looked at the definition of victim from the Constitution. Victim means a person against whom the criminal offense has been committed, or if the person is killed or incapacitated, the person's spouse, parent, child, or other lawful representative, except if the person is in custody for an offense or is the accused. There's no reference to suspect. So the court rejected a purposive interpretation, which the dissent carried the torch for, and readily held that Mrs. Knapp was not a victim, or was a victim and was not excluded under that definition, and therefore could exercise the rights pertaining thereto. A more recent case which illustrates originalism and interpretation of the VBR is State v. Patel. That happens to be a case that I authored on behalf of a unanimous court, which means that my law clerks did a lot of work on that too. So, this case involved the conflict between constitutional rights and statutory provisions concerning the specific right to restitution that's set forth at Section 2.1A8 of the VBR, which guarantees a victim's right to receive prompt restitution for loss or injury caused by a defendant's criminal conduct. Now, as I read earlier, Section 2.1D authorizes the legislature to enact laws to define, implement, preserve, and protect the rights guaranteed to victims that are set forth in the section. So we had to look at whether Section 28-672G, which was provision enacted by the legislature and limited the amount of restitution to $10,000 for loss resulting from violation of specific criminal traffic offenses, was either an unconstitutional limitation on the right to receive restitution or it was a valid legislative enactment. Now, the victim in the case had established that their injuries and expenses amounted to $161,000 and change, and the defendant's insurer had already paid $100,000, so the amount in question was over $60,000, 6 times the amount the statute purported to limit an award of restitution to. The defendant argued that the court could order no more than $10,000 based on the statutory limit. The state argued that that statutory limitation was facially unconstitutional because it conflicted with the right to restitution under Section 2.1A8. The municipal court agreed with the state's argument and ordered the defendant to pay restitution just over $60,000, and the defendant appealed. In a lower court appellate review, the Superior Court reversed the municipal court's order, reasoning that absent the words full, complete, for all losses, or with no limit in the text of the VBR, the Constitution did not guarantee the right to, quote, full and complete restitution, close quote. Therefore, the statute limiting the award of restitution was a valid policy decision of the legislature. The Court of Appeals reversed and reinstated the restitution order, holding that the common understanding of restitution, along with the plain language of the VBR and related jurisprudence, necessarily guaranteed victims an award of restitution for the full amount of economic loss. The court further concluded that the statutory limitation on restitution did not, quote, in any way advance victims' rights to restitution, close quote, and thus it was not a permissible exercise of authority under Section 2.1D. In briefing before the Supreme Court, the defendant focused on prompt in the phrase prompt restitution to argue that Section 2.1A8 did not require full restitution because, quote, no torture of the English language could possibly transform the word prompt into that of full or unlimited. The court agreed. Prompt does not mean full. Referencing dictionary definitions, the court noted that prompt, now I will say this, because this was passed in 1990, we didn't have to go find a 1912 dictionary, so this was far easier. The court agreed that prompt did not mean full. Referencing dictionary definitions, we noted that prompt meant being on time, punctual, carried out, or performed without delay, a prompt reply. Therefore, prompt in the context was an attributive adjective that modifies restitution temporally. I will say that again. It is thus an attributive adjective that modifies restitution temporally. Nobody would ever believe I'd write something like that. Any conclusion that the amount of restitution a victim may receive based on what prompt meant was therefore a non sequitur. Whether Section 2.1A8 guaranteed full restitution then depended on the meaning of restitution itself, which was not specifically defined in the VBR. So nonetheless, we looked first to Knapp to quote that following and applying the plain language of the VBR is what we do. And we agreed with the Court of Appeals that the ordinary meaning of restitution was to restore someone to a position they occupied before a particular event. We then considered the scope of restitution afforded to victims at the time of the passage of the VBR, at which time victims were clearly entitled to full restitution, and we could look to ERA Section 13-603C for that proposition that provided that the court shall require the convicted person to make restitution in the full amount of the economic loss as determined by the court. And just as we presume that the legislature is aware of the law when it enacts a statute, we presume voters are as well. We also looked at arguments and analysis in the publicity pamphlet, which supported the conclusion that voters sought to guarantee a right to full restitution. Arguments in support spoke of the need for a constitutional right to restitution, while arguments in opposition specifically noted that statutes already guaranteed the right. Legislative analysis noted that the requirement for the defendant to pay the victim for any harm caused acknowledged that the victim had been harmed and should be compensated for that harm. So, quoting that same language, the Court of Appeals had concluded that, don't you feel good that I'm quoting the Court of Appeals so much? Maybe not. The Court of Appeals had concluded that given the reference to payment for any harm, we find it implausible that the electorate intended to only guarantee a victim partial restitution. And we thought likewise and concluded that given the text in question did not limit the amount of restitution, we would not restrict the guarantee by adding words of limitation contrary to the plain language used. Therefore, the VBR guaranteed full restitution for crime victims. Now, in briefing as well, an argument the defendant had asserted that such an interpretation would rewrite the VBR to read, victims have an unlimited right to restitution, unhampered by any statutory directive. However, we observed that while the amount of compensation owed to a victim could vary depending on the crime and resulting harm, the loss for which restitution could be awarded was not unlimited. Section 2.1A8, again going back to the plain language, limits restitution to loss or injury caused by a defendant's criminal conduct. The particular nature of the loss in question is further clarified in statute and our case law. Section 13-105, paragraph 16 provides that economic loss includes lost interest, lost earnings, and other losses that would not have incurred but for the offense. Economic loss does not include losses incurred by the convicted person, damages for pain and suffering, punitive damages, or consequential damages. So accordingly, the plain meaning of words and the state of the law at the time of passage, as well as contemporary materials, provided the tools for us to discern the understood meaning of restitution when the VBR was passed. Thus, while of relatively recent vintage in comparison to other provisions of our state constitution, Section 2.1 of the VBR is part of our organic law and equally capable of an original public meaning interpretation. Thank you.
I wanted to follow up on that with a question that I think maybe just sort of restates what you just said. My apologies to the audience for that, if that's true. The VBR is a relatively recent edition, which has relatively direct and specific language, clear language, one might say, and for which we have substantial voter materials and other sort of publicity materials. Does that suggest a different originalist approach for interpreting it as opposed to other provisions of the Constitution? Is it, or like more ancient provisions? Is it more straight textualism? Is it like a demystified originalism? Is it just the same thing but with better footnotes? Like, what's the approach?
Or faster research. I think what you could say is when we look at Section 2.1, it is of more recent vintage. Therefore, when we apply those tools of discerning meaning through an original public meaning framework, it's easier to draw from more recent history and to illustrate how those tools work. As you go back further in time, for example, if you're going to try to determine a contemporaneous meaning of a word and you're looking at sources at the time, you've got to be careful about not picking and choosing which sources you want to use to determine your definition. So if you wanted to go all the way back to a more recent case that the court decided, and both the majority and the dissent engaged in an originalist interpretation, looking at Constitutional Convention minutes, what was being discussed at the time, and actions of the first legislature and the first few decisions of the Supreme Court interpreting it, you can't just pick your favorite 1910 newspaper from Bisbee. You've got to survey to make sure that you have an even-handed approach to trying to discern what that means. With Section 2.1, it's far easier to do when you can look at a publicity pamphlet and see exactly what the proponents sought to do. And at least in this particular instance, you're also able to see the arguments of proponents and opponents and see what they understood the words to mean as well. And I think that gives us on this side of the bench a bit more confidence in saying, well, this is what the words mean, and therefore this is how they apply.
And that seems like a pretty good summary of originalism. I hope you will thank our panel for their presentations today.